As with other technological advances, AI is testing the limits of intellectual property ownership. General-purpose AI developers, including OpenAI, Microsoft and Google, train their models on massive amounts of digital content. Text and images provide information that is needed so generative AI tools can respond to a vast array of prompts. When you ask ChatGPT a question, its answer is derived from such acquired knowledge. Even if the result isn't an exact copy of specific content, it will be a reflection of it. Should original content creators, artists, authors, and academics whose works are part of training this AI have a say when it comes to the inclusion of their content? Individuals and creative industries rely on intellectual property laws to protect what they produce. The EU's AI Act, which passed a European Parliament vote in March 2024, refers to existing copyright rules. These grant the creator of an original work the exclusive right to reproduce, distribute, modify, exhibit, and perform it. In the EU, such rights can be used to monetize work and traded for 70 years after the death of the creator. After that, the work enters the public domain and can be freely reproduced. This applies to books, music, plays, paintings, and many other forms of artistic and scientific content, which explains why older content is more widely available. AI increases the scope for all digital content to be accessed and replicated in ways that blur the divide between inspiration and emulation. We see many examples of well-known styles being emulated. The resemblance is often so striking that it's almost impossible to distinguish from the original. In Europe, the AI Act prohibits developers of general-purpose AI models from using materials without the authorization of the copyright holder. They must apply the necessary technical means to identify and respect protected content. A new AI office will oversee the implementation of the AI Act. It will issue a template for developers to keep records of data used to train their model. Developers must fill in this template for transparency. There's an exception to the use of copyrighted materials for AI training for text and data mining, and an exception to the exception for scientists. Rights owners must opt out to prevent their works from being used to train AI. The AI Act also applies to general-purpose AI providers who develop technology outside the European Union. In countries like the US, absent a similar legislative framework, many disputes over the use of copyrighted materials are before the courts. OpenAI are being sued by the New York Times, as well as by comedians and writers who allege their works are copied without permission or consideration. The EU's focus on record-keeping and traceability could help ensure disputes are rapidly resolved so copyright is upheld, as well as encourage AI developers to factor requirements into their policies and into the tools they develop and deploy.